Good evening, ladies and gentlemen. A very warm welcome to all our participants, dignitaries, and our esteemed speaker, Honorable Mr. Justice B.N. Sri Krishna, retired, to the seminar on data privacy organized by the IMC Chamber of Commerce and Industry. All participants will be muted to avoid any disturbances during the course of the session. To consume less bandwidth and have clarity, you are requested to stop video streaming at your end. Kindly post all your relevant queries in the chat section so that the same can be addressed. As we begin the session, may I request Mr. Rajiv Poddar, President, IMC Chamber of Commerce and Industry, to present the welcome address. Over to you, Mr. Poddar.
Good evening, ladies and gentlemen. It's my proud privilege to welcome you all to today's seminar on data privacy organized by IMC's Law Committee, a very important and hot subject. The objective of today's seminar is to appraise the participants on various aspects, core principles, and important dimensions of privacy and data protection. As the President of IMC Chamber of Commerce and Industry, I would like to extend a special and warm welcome and thanks to our speaker of the day, Honorable Justice B.N. Sri Krishna, for sparing his valuable time and being with us today. Thank you very much, sir. Sri Krishna ji needs no introduction. He is an Indian jurist and a former judge of the Supreme Court of India. From 1993 to 98, he headed the Sri Krishna Commission that investigated cause and apportioned blame for the Mumbai riots of 1992-93. He is currently the chairman of the Financial Sector Legislative Reform Commission and also works as an independent arbitrator. With the increase in user generation, data, and the exponential industrial value of data, it has become vital for the government bodies to take necessary steps to protect the data rights of their citizens. Data protection regulations ensure the security of individuals' personal data and regulate the collection, usage, transfer, and disclosure of the said data. It is vital to provide proper access of data to the individuals and also place accountability measures for organizations processing personal data and supplements it by providing remedies for unauthorized and harmful processing. Recognizing the importance of data protection and keeping personal data of citizens secure and protected, the Ministry of Electronics and Information Technology, Government of India, constituted a committee of experts under the chairmanship of Justice B.N. Sri Krishna, former Judge, Supreme Court of India. The draft bill was presented to the Ministry of Electronics and Information Technology on 27 July 2018. It seeks to protect the autonomy of individuals with respect to their personal data, specify norms of data processing by entities using personal data, and set up a regulatory body to oversee data processing activities. I also welcome Mr. Swapnil Kothari, member of the IMC Law Committee, senior lawyer, managing partner of S. Kothari and Company, for our moderator of our today's session for putting this event together. Before I conclude, a brief about IMC. Established in 1907 and having its headquarters in the heart of the city of Mumbai, the IMC Chamber of Commerce and Industry is an apex chamber of commerce, trade and industry in the Western region with its membership base of over 5,000 members and has over 150 trade associations affiliated to it. Together, it represents and advocates interest of over 4 lakh business and industry establishments across the country from diverse sectors of industry. Once again, a very warm welcome to today's seminar. Thank you for being with us. Now, without any further delay, I would request Mr. Swapnil Kothari to take over from here and begin this much awaited session. Thank you. Swapnil bhai, over to you.
Yes. I think Sia is going to give some introduction.
Sia?
Yes. Good evening, everybody. I welcome everybody, our Honorable Speaker, Honorable Justice Mr. Sri Krishna, and I also welcome Swapnil Kothari, who will be moderating our today's session. Mr. Swapnil Kothari is a founder and managing partner of his law firm, S. Kothari and Company, Advocates and Solicitors, and practicing in Mumbai since the past 20 years. He practices in corporate sphere with an emphasis on banking law, property law, project finance, joint ventures and mergers and acquisitions, including some litigation, arbitration, IT-related matters, and high-profile NRI investments. His clients include major shipping and pharmaceutical companies, international banks, domestic banks, and financial institutions, as well as other high-profile NRIs and individuals. A commerce graduate of NM College, after his LLB from Government Law College, he pursued his LLM, International and Comparative Law, from a Georgetown in May 1995 and worked with the Slaughter and May London and John's Day, Scleville and Amarchand Mangal Das Mumbai for a couple of years before setting up his office here. Oft quoted in Times of India on seminal legal issues and a panel on several super prime time shows on major national channels. He is also on the board of several Fortune 500 Indian companies. He is a member of IMC's Law Committee and also the President of Council for the Fair Business Practices and nationally renowned NGO dealing with the cause of the consumer. Thank you so much, Swapnil sir. May I request you to take over from here? Thank you so much.
Yeah, thanks, Sia, and it's a great pleasure to have you, sir. Justice Sri Krishna, sir. It's my honor because personally, I've known you and your family since a long, long period of time, and it was always one of my dreams to have you on the other side, and where I start firing questions, and you have to answer. And I know, I'm still going to fall short of your intellect and wisdom. Even if I've done a decent amount of research, and that's exactly the way we want it to be, because we want our elders and our seniors to be right at the top, putting their best hands on our heads so that we can go ahead and achieve much, much bigger milestones and make you all proud. I also thank Mr. Rajiv Poddar, the president of IMC, who is also a very dear friend, and for giving me this honor, for giving me this opportunity to be at the center stage of one of the most important topics today, which is in fact a hot controversy, and in many ways which is going to really get the Supreme Court and also the high courts of the country thinking and trying to grapple with this major issue, and possibly get into this case after case. Now with that, without further ado, I will request His Lordship to get on with his PowerPoint presentation. I believe he's got one. So, Sia, could you please, get in line with the judge as to how he wants it, and I leave it to you, and then I'll start asking questions.
Swapnil, there is no option. It's quite feasible. If you want to just ask questions, I'll answer them. Since I had a PowerPoint which I had prepared, I sent it to you. That's all. That's not obligatory, because then once I do the PowerPoint, I'll have to talk along with it, and you will take away so much time on that.
Sir, what I suggest is that since most of the people who in the audience would be non-lawyers, so I would appreciate if you for at least 5-10 minutes touch on the key points of the PowerPoint, so at least people have some kind of a backdrop as to what's going on.
Okay. Then ask somebody to put the PowerPoint.
Yes.
I'll quickly flip through it without going into too many explanations.
Sure.
Right. Now, I noticed how Swapnil's eyes lighted up to say that there will be more and more cases in more and more courts because of data protection law. As a lawyer, that's exactly what you want. All right. Now, let's go to the... Now, what is right? First of all, what is privacy? Privacy is your inherent human desire to be left alone without being bothered by somebody, without being monitored or snooped by somebody always. Now, whether this is a right at all was under a lot of debate. Then the next question was whether it's a fundamental right. The Supreme Court ultimately had taken conflicting views in several judgments. And finally, in the Puttaswamy case, which was in connection with the Aadhaar card, Supreme Court clearly laid down that it's a fundamental right founded on Article 21. Now, no fundamental right can be abridged without a parliamentary law, and Supreme Court laid down a triple test in order to ascertain the constitutional validity of such a legislation. Thank you. Next, please. Now, at the background to the appointment of the Committee on Committee on Data Privacy Law was that when Aadhaar was being challenged in the court and the Supreme Court was hearing the validity of the Aadhaar constitutional validity, two questions were raised. One is whether it is constitutionally valid, and because it's a fundamental right. Number two was whether there was any law on privacy at all in this country. And post haste on a Friday evening, when I was about to leave for New York, I got a call from the Minister of IT, the then minister, saying that we have to tell the Supreme Court that we have appointed a committee. We want you to be a chairman. And then they managed to placate the Supreme Court for some time on that. And then the committee went into it, looked at the law all over the world, and tried to take the best of whatever was available, and then suit it for the genius of this country and the people of this country to come out with a law, which resulted in a bill which was posted, a report which was given in 2018 along with the draft bill. The bill was kept pending for about a year. In 2019, the government made several changes therein and then referred it to a joint parliamentary committee. Until today, the joint parliamentary committee has not been able to arrive at a consensus and then put back the bill in parliament. That is what, so far as the law is concerned. Next, please. Now, a quick look at what is all this subject. What is data? Data is the nature of a right to data. Now, who is the person who owns the data? Actually, the word owner is a misapplication of the term. There is nothing like owner of a data. You have an intimate relationship with the data, which makes it valuable. Now, take for example, I can say that I am the owner of this mobile, which means that I can throw it in the dust basket, I can gift it to Swapnil, I can sell it, I can mortgage it, I can rent it. Can I do that with my name? Can I do that with my address? I cannot. That is why it is called an intimate relationship, jurisprudential relationship. But it's very valuable. There is no doubt about that. Next, please. Now, data can be of several types, some which are called critical data, some which are sensitive because it deal with personal aspects. Now, anything that identifies me as a human being is my data. It could be my name, my address, the color of my face, the formation of my eyebrows, my eyes, all my physical biometrics, and anything that is relatable to me is my data. Now, the question is, if I have this intimate relationship, I don't like to use the word owner, but I have this jurisprudential relationship with it. Am I allowed to part with it? Can somebody take it without my consent? So the fundamental rule in data protection is that nobody can take away my data unless they take my consent. But next, please. That this consent is a very complicated issue because consent, as you all know, anything that is taken by a person from another person has to be the subject matter of the law of contract if it is to have a legal relationship. Now, the Indian Contract Act clearly says that a minor cannot consent. A minor's consent is invalid all the way from the Privy Council judgment in Mohori Bibi's case. Still today, that is the law. Therefore, if a minor has entered into a contract to give away the data, is it valid, is a big question. And today, these kind of issues are haunting us because there is a lot of activity on the web, on the internet, even by minors. And the consent is obtained by simply a click, saying that if you click on this, you are deemed to have waived your privacy rights. Now, whether that is right or not is a big issue which needs to be considered by the law. The next, please. Then we have issues like emergency situations, or where a court directs it has to be done, or situation for employment purposes. I employ a person and then he goes and somewhere else, the other person will ask for details about my employee's residence, and that resident will be a part of his data. Or the state might want to acquire my data for under certain special circumstances, like, protecting military secrets, protecting the sovereignty of the country, protecting things like criminal investigation and whistleblowing acts and things like that. Then when the next is, when the data is required, everybody is throwing away data without understanding. You walk into a hotel, you charge your card, everything there gets registered on their computer. All your data is acquired. You go into a shopping mall, your picture is taken there, that is your data. They take away your address, telephone number, card number, bank account number and all that. Now all that is to be processed by somebody. Process is used in a very technical sense, that even if you keep it at one place on the computer, that is called processing. Now the processing may also involve making suitable alterations therein for suiting a particular purpose. So I might want my data to be processed by X. X may say, I don't have power to do it. I will not be in a position to do it. I'll hand it over to Y, who will be doing it. Now if that is done, and if there is a breach of the data gets, and a breach, what is a breach? Breach is unauthorized access to my data without my consent. Now if that happens at the second hand, now who is responsible is one of the questions that needs to be seriously considered by the law. Then processing, then the data principle. Now the question is, next please. Who is the principal? Actually, in all the laws that are there, both in GDPR in Europe and in the American law and South African law, the person who holds is called data subject. And so I said, what subject? I ceased to be a subject when the Queen was, we took leave of the Queen of England. After that, nobody in India is a subject of anybody. I'm not the subject of Parliament. I'm not the subject of the President of India also. I'm an independent person, citizen with certain rights. So I said, I totally object to this subject. So we said, we'll call you principal. Why do we call you principal? Because it is my data. I'm giving it to you. I'm the principal. You are the person. But don't forget that you are taking it under an obligation that you, therefore we call you data fiduciary. Now, this is a very interesting concept in law of having a fiduciary relationship. Then there are so many aspects that I have a right as a data principal, right to information and access, confirmation of data on record, correction and updating data probability, portability, and right to be forgotten. I'm sure about which really, Swapnil will ask me hundreds of questions which I'll have to answer. Next please. I'll quickly run through this in another 5 minutes and then you can start shooting questions at me. Then privacy by design. Privacy by design is a concept that just like, for example, I'll give you an example. Before the Supreme Court judgment in Vishakha, there were people did not know what is the sexual harassment at workplace. Vishakha put in place this concept. And of course, subsequently it has been incorporated into parliamentary legislation. What does the law require now? That every company which employs women should make it a policy that there should be no harassment, and therefore they are required to educate their staff and also put up on the notice board what can be done, what cannot be done, and these committees which are to be appointed for the purpose of dealing with the grievances of women. That is called, that same principle applies here. The privacy by data means, by design means, you must educate your staff to know that data has to be private. It cannot be accessed without consent of the person or the data principal. And under what circumstances it can be done, and who has to be notified in case of unauthorized breach is all to be said in this privacy by design. And that every company will have to statutorily appoint persons to look after that. Like you have compliance officers on other subject, there will be a compliance officer in data privacy also when the law really comes into force. Then there will be, just like you have a regulator in every sector. For example, the Reserve Bank is a regulator of banks, SEBI is a regulator of capital market, Insurance Authority has its own regulator. Similarly, what is proposed is that there will be a data protection authority. Next, please. Data protection authority. Next. And the data protection authority will be a body which will ensure a constant interaction with different sectors of industries, understand what are their best practices in the matter of data, crystallize them after debate and long discussions into regulate them into regulations which will be applicable across the world. And one interesting thing is this law is intended to apply equally to all government departments as well as private companies and individuals also. Of course, there will be a threshold limit that yes, we don't want it to apply to a corner shop, pan bedi dukan. Although technically it will be there, that may be exempted because you require a particular threshold. Otherwise, it will be impossible to monitor the data of every person in the country. Then next, please. Then data fiduciaries, the persons who receive the data and process it are called fiduciaries, and there will be a classification depending upon your total input and the total volume of data that you handle and the total amount of money that is generated in the bargain. Then one important thing is cross-border transfer of personal data. Now, should the data be taken across the country to some other country? There is a principle known as here, the principle of adequacy, namely that if you can ensure that the other country has the same protection to data which I have in my country, then you can enter into contract with a country in England or America or wherever else and transfer it freely. Otherwise, there should be some restriction on this. Next, please. That is the adequacy test. Then exemptions. Should anybody be exempted? Of course, all government departments will say, you may do whatever you like with the others, but exempt us. So should this exemption be so freely available? Should the state be allowed to, today we have this big debate about Pegasus. That is one of the issues that will have to be carefully considered now. Can anybody take away my data by tapping my mobile or my computer or my WhatsApp messages is another issue which requires carefully. And certain activity has to be exempted. Like for example, you require data to do statistical research. You require data to do historical research. You require data to do medical research. Now, without data, how can I do medical? For example, if I want to give an answer to the question as to whether which group of people are most likely to be affected by COVID, I can't do it unless I do statistical research. That is why medical data has become a very important issue in protecting the health of the persons. And therefore, in such cases, the law will give them some exemption. But there is a hedge-in thing, namely that you may require medical data of how many persons were admitted in the JJ hospital with COVID. But why do you need who was admitted, what was his age, what is his wife's age, and what are these children? Why do you need that information? Therefore, there is a concept known as anonymization. You knock out the details and take only 100 people were admitted of these various symptoms. They were treated, they were discharged, this is their progress, this is their monitoring their health. That kind of research is permissible. Next, please. Then the Data Protection Authority, as I told you, is a regulator who will be in charge of making sure that the law is followed everywhere by all the entities. And if there is any data breach, immediately a report has to be made to the Data Protection Authority. We had proposed that the Data Protection Authority should consist of majority of independent persons who are experts in this field, maybe from this country, from abroad, even academicians. But under this 2018 bill, it is absolutely filled with government nominees. Whether that allows it to be independent enough is an issue that needs to be considered. Then next. Now, when does the Data Act commence? We had suggested that to start with, when the Act becomes operative, you will set up the Data Protection Authority, who will be given 6 months' time to work out all the regulations and then apply the law bit by bit like you did in the case of Companies Act. But presently, the data bill that has been proposed in 2019 only says that it will come into force on such date as government may notify. And if the government doesn't notify it for the next 15 years, there won't be any law for the next 15 years. Then next. So this is a very helicopter, not even helicopter, it's a MiG run over the data protection in the sky. And I hope I've been able to identify some of the highlights. And now it is up to Swapnil to ask questions. And
yes, thank you very much, sir. I think that was, that formed a very decent background, and a lovely synopsis of what we're going to talk about, so that the participants would, now understand the tone and the tenor of the question. Puttuswamy judgment stemmed out of Aadhaar leaks, or when all the data started getting inscribed into Aadhaar, my bank accounts, my mobile phones or my suggested mobile phones, my passport details, everything else. Do you think, Lordship, that this really fueled the right to privacy debate And that is the reason you do not often find, when a constitution bench sits, a unanimity of 9 judges together in establishing right to privacy as a fundamental right. Of course, there were conflicting decisions here and there before, but to have 9 minds sitting and agreeing to one fundamental concept that yes, right to privacy is a fundamental right. Do you think that the Aadhaar leak was so gross and so egregious that we had 9 minds, the most brilliant minds of the country, because according to me, the Supreme Court has got the best minds in the country. And
thank you for saying.
No, surely, sir. So do you think that 9 judges really came out because of that?
See
together?
Point, people don't know this. In fact, somebody was arguing with this and saying in our country there is no concept of privacy. You know, way back, I'm talking of the good old days, and when Vishnu Gupta he taught Hitopadesha. In that he says, Ayurvittam Grihat Chidram Mantram Aushadham Maithune Danam Manapamanocha Navagopyani Gopayat. He identifies 9 things and says, these 9 have to be always kept confidential. So the right of privacy was there. Now, unfortunately, for 300 years we have been ruled by Britishers. So we forgot all that, and we thought that, oh, this is something that is like our craze for imported cars and imported various things is also imported from abroad. No, it is not imported, very much there. What we are told, what you need to be kept as confidential. Now, apart from this, all over the world, this concept that every individual is born with a fundamental right is accepted. What is a fundamental right? Fundamental right or a human right is not given by anybody to me. It is my inherent in my nature as a human being. Now, therefore, you notice human beings have this tendency to say, don't bother me now, don't leave me alone. This is the right to be left alone, and the right to not to be pestered by unnecessary intrusion is the right to privacy. Now, Aadhaar leaks is actually Aadhaar leaks, and let me tell you, since I studied that thing, Aadhaar leaks is not really so much the government to be blamed as the people who handled it. Because the technical things are really very good. I had to go into this very much. And in fact, I had a long 3-hour discussion with Mr. Sharma, who was heading the CEO, heading the Aadhaar committee at that time, Aadhaar project at that time. Now, yes, this is the difficulty. When the data is handled from hand to hand, there is bound to be a leak. So who is responsible for it was the big question. And the activists in the country said, hey, this is my fundamental right, you are so negligently handling it, therefore you should not ask for this at all. But there also there may not be a correct, you see, all over the world, if you notice, even in United States, there is what is known as social service number. That is unique to everybody. In Singapore, there is a citizenship number or something like that. In Africa, in South Africa, there is one. In Europe, in many countries, you have this citizenship number or residency number or something else. So it is not unique. In this country also, it would have been a good thing. But unfortunately, this inability to handle it securely gave rise to this hue and cry. And therefore, and in view of the conflicting judgment, the Supreme Court 9 honorable judges sat together and said, hey, this is a fundamental right of a citizen. You can't tamper with it unless you have a proper law enacted by Parliament with 3 constitutional principles. One are the law must declare the objective, the law must be disproportionate, and the third is the law must, what is the third one? Not disproportionate, and the law must
equal, not arbitrary.
Correct. It acts rationally and not arbitrarily. So these are the 3 principles which the Supreme Court laid down in Puttaswamy case.
Okay. Since you mentioned the social security number aspect of the United States,
yes,
the United States does not have a single data protection act or a data protection law like the United Kingdom.
yes.
United Kingdom has got a data protection act, and we usually, sort of borrow a lot of things, or not borrow, should I say, now follow since years, since we have a parliamentary democracy. Unlike the presidential democracy of the United States, we follow more of the English law and the way the English people have drafted the act. Now, the US Act has been interspersed in many different acts. For example, just to...
Swapnil, that is the reason we did not look at US at all. In fact, when I was doing the committee, US didn't have a single law. It's only in May of 2 years ago that they came out in California only has this law.
Right. Right. I agree with you, sir. But what I'm trying to say is that, say, for example, the United States has got, the Gramm-Leach-Bliley Act, which governs the protection of personal information of banks, which is there with banks. Then you have, the portability, the Information Portability and Accountability Act about health status and all those things. Then you have, the family educational rights where you protect, college records, etc. So your data is interspersed under various acts, and the implementation of these acts is taken very seriously. Do you think that the data protection bill, assuming that it gets enacted into the law, would really be able to deliver justice, or should I say be able to be implemented? I mean, what I think, Your Lordship, is that we have got many laws, but our implementation is where we fault in many things. I mean, we are second to none in having the best laws in the country, but its implementation is where we really lack. And that is why the Supreme Court today is saddled with so many things that it should not be saddled with at all. That is not the job of the Supreme Court today. What the Supreme Court is doing, the Supreme Court today is dealing with religious and vociferous tendencies today, with religious issues, which we do not have to really worry about, with appeals, certain appeals by way of SLPs, which otherwise would have never made it to light of the day in the Supreme Court today because of the sensitivities involved. I don't want to get into further details because that's a topic for another day. But do you think that the implementation is going to be proper in this country with the data protection bill, or are we going to still see a lot of issues? Because the last thing I want is courts to be inundated with unnecessary cases.
See, that is why the Supreme Court had, I remember, I forget which is the judgment, in which we had said that every time Parliament legislates, there is what is known as the financial, in the bill, there is always a financial report of the Finance Department note. So we had simply said, we had also said that every time a bill which affects a new law, which enacts a new law is passed, apart from the Financial Ministry note, also make a note and say how much a burden it is going to cause on the judiciary. How many courts will have to be established, what kind of procedure will have to be followed.
Exactly.
That, of course, is never followed because courts are not very high priority in this country. Now, to answer your question, really, the object of a law is twofold. One, to establish a norm. You see, today, what has happened is you are worried because how are you going to implement it? People don't even understand. Now, if you look at an act like Companies Act, you had the 2013 Act. In 2013, if you looked at what was happening in England and what happened in India in 2013, all the scams that took place between 2013, which gave rise to the 1956 Act. 1956 Act was also implemented. Maybe it was implemented badly. Then that gave rise to a new kind of insight. Then you come to the 2013. So this is a continuous process of evolution. This is just the first act. You never had an act in this country. Therefore, we are so worried, how are you going to monitor it? Now, if monitoring is the test of the law, do you think IPC is being monitored very much? Are there no criminal cases going on in the country? Are the criminal cases not inundating the judges and the courts? So the monitoring is another aspect of the matter. First of all, the law establishes a standard which by constant interaction, the citizens will take it into their mind. Now, the Bombay, if you have visited the High Court so many times, on the central staircase in the corner, everybody spits. Have you seen the board there? It's a shame to have this. Now, that is necessary because people must understand it, that you should not go and spit here. Now, if everybody understands that, then monitoring becomes easy. It is the first step that the law takes, which makes people aware of the norms. And once the people, this certain education is there, then monitoring is not difficult. Today, monitoring a company is not very difficult, or monitoring a capital market is not very difficult because people have become trained in it. It takes time. It was the first step, no?
Right. And I completely agree, Your Lordship, with this. But my only concern is, that you've put in so much of hard work to get a data protection bill. You and others, I would say not only yourself, but I'm sure a lot of people have put their heads together and tried to come out with something to really address the issues and to really see. Otherwise, what happens is that the right to privacy becomes a teasing illusion.
Absolutely.
It's a 9-judge bench. It's a teasing illusion. It doesn't give me the confidence. I'm very happy that the most brilliant minds of the country are giving me something which is within their periphery, and they are overstepping so many times to do complete justice, and even invoke Article 141 or 142 so many times to ensure that complete justice is done. But what happens is that today the executive and the legislature seem to be taking the judiciary, okay, they are there, we'll see what we can do. They are doing very lackadaisical job. That is where I feel that somewhere in the Data Protection Authority or the Data Protection Bill, now see the data fiduciary is there. Okay, let's say the data fiduciary. What is this? You've given a fantastic nomenclature, sir. Fiduciary duty between doctor-patient, lawyer-client, uberima fide contract, best good faith, utmost good faith. So you've given that nomenclature to them. Do you think that the data fiduciary is going to really have that conscientious nature, which, we will assume that you've given that, but at the same time, I want then penal provisions to attract to him, to apply to him. Today, we are crying hoarse, sir, about Article 44 or Directive Principle of State Policy, Uniform Civil Code. हमारे देश में criminal code एक है, IPCS. Several laws are there. एक civil code नहीं कर सके हम लोग. What we are trying to say, the Supreme Court has tried hammer and tongs, has gone after this, but the legislature and the executive are not doing enough to do that. So that is where my point is coming in, sir, that do you think that the Supreme Court should really crack the whip as far as this is concerned when the Data Protection Act comes in, that look, we are going to entertain only this up to a certain extent, not beyond that. Yes, it may sound a little bit absurd and may, transgress constitutional parameters as such. But let me tell you, sir, today, because of too many unwanted litigations coming to the highest court of the land, a lot of people are not approaching the Supreme Court, or a lot of people are being deprived of justice. That is my only concern. I'm looking at a larger issue. That is why I'm asking you about data fiduciary and a data protection. And then I'll ask you about minors once you answer this question.
No, the question, Swapnil, is this. Therefore, do we say that we don't want a data protection law?
No, because we must.
Yeah, therefore, the answer is not in the law. The answer is, how do we as citizens, including the institutions which are intended to enforce this, make sure that the law moves smoothly and the law is implemented smoothly? It has two answers. A, honesty of purpose on the part of people who are to enforce the law. But if, look, all factories, take for example, Factories Act. Factories Act started in 1948. You know it worked. Today also, there are so many amendments there. And factory inspectors are notorious for making money.
True.
Everybody knows that. Same thing with income tax. Therefore, can we blame the law? The law is necessary. Otherwise, how do you run a country if you don't have a Factories Act? The Factories Act establishes a norm. It says you will have this kind of a building, this kind of equipment, this kind of safety measures. So therefore, maybe even out of 100, 10 fellows don't follow it, 90 fellows still follow it, no? Because the law is there.
True. I agree with you, sir. I'm fully with the fact that the law should be there. It should be implemented as fast as possible. It should be converted into the act as fast as possible, so that the right to privacy has got its meaning. We've got a fantastic theory in right to privacy. Puttaswamy must have tried very hard for that. We've got Aadhaar in place. We've got so many things in place today. My only thing is that when it reaches the grassroots, that is where then the law. I'm not blaming the law. I'm not blaming the Supreme Court at all. I am very much in favor of the Supreme Court, very much in favor of the people who have worked hard. I'm only wanting to ensure that in some form, the judiciary, let's be fair enough, sir. You and I have seen last 3-4 chief justices in this country. They have given the best judgments possible, and it is the judiciary which is running the country. Let's be very honest about it. Otherwise, this country, you may or may not agree, sir, but according to me, the judiciary is practically running the country for the next 100 years. It has given some fantastic judgments on homosexuality, adultery, and whatnot. I don't even remember quite a few judgments now that are there. Privacy, for example. So, so many judgments. So that is where my only concern was that somewhere, this should not, be a mirage to me. That's all. I want the law to be there. I only want its implementation. And that's where I'm asking nuggets of wisdom from you, your lords. I want to understand from you.
I agree with you that the judiciary is virtually running the country is what I have been saying myself. In fact, I said for 5 years, let's not have elections, let the Supreme Court run the country and make it straight, and then we'll have elections. But you can't agree to that in principle in democracy. As a joke, I have said it, that if Pakistan can run without parliament, we can also run with the Supreme Court running the country. But that is not proper. If you really have your heart on democracy, you are bound to have this Because, ultimately, please remember this famous saying that you deserve the government that you get. So if you think we are all honest, if we think that we are all disciplined and law-abiding, then there is no need for us, anybody to monitor us. But we are crooks. Then you have to have a police department. The police department itself will have to have a police department, a CBI on top of it, a chief vigilance commissioner on top of it, and then on top of it the Lokpal, and on top of it the Supreme Court. But why do you need all this then? You need it because we are dishonest basically.
Okay, fine. I got yours. I got it, sir. Now I want to move to a very important point that you mentioned about minors. Now minors today are having access to, let's say, whatnot.
Yes.
By clicking on accepting the terms and conditions, the computer does not recognize whether you are below 18 or you are above 18. It is going to go by the click. Moiri Bibi versus Dharmodas Ghosh, you mentioned that very celebrated case. We all know that minors do not consent. They do not have the right to consent. In today's day and age, when minors have access to so many things, let's say a 16-year-old has access to so many things, how do you reconcile the data protection law, a valid consent, and the protection of the family of the minors if the minor is being duped or deceived into sharing information which his family, who are adults, would not have otherwise shared? How do you think that the Data Protection Act or the data privacy law will address this concern?
There are two issues here. One is the liability of the minor. Now, the moment it can be established, even though normally what happens is in the website, it says, are you 18? A smart child will say yes. What is your date of birth? It will give him exact date of birth, it will make him 18. And are your parents agreeing to it? Yes, yes. Right? The man at the other end will not know it. He will continue the contract. If a situation arises of imposing a liability on the child, the law will certainly protect it because we have said anybody less than 18 they cannot have a valid contract at all. Therefore, if it's a question of imposing liability, it is out. Because that has been the law in this country as far as contract is concerned.
True.
Now, the next question is, this is different from, for example, there may be some websites which are obnoxious from the point of view of the child. Controlling them is not the job of the Data Privacy Act. Data privacy is taking your data away.
Correct.
The two things that issue. Then, for example, your POSCO and all that, they will take care of that. Protection of the child from evil influences is a different matter. On the contrary, I'm saying that today's kids are so smart that even less than 18, they need to be given access. I'll give you a simple example of my own grandson who is just about 10 last month. Last year when I had gone to London, then he was asking me something. And I said, hey, you know this? He had asked me some question in mathematics. I said, this is something I learned in my BS class. How are you knowing it? He said, don't you know, Granddad, that I am a member of the Khan Academy? I said, what the hell is this Khan Academy? Then he showed me the computer and he had access to that. See, Khan Academy is a really very respectable academy. You are Byju's in India today. It's a respected academy which they teach them. Now, a child who is teenager, say between the age of 10 to 15 or 10 to 18, wants to have access to all this. Now, if you make a law and say less than 18, you can't have access at all, you're depriving the child of something that he is entitled to. So this is a dilemma which needs to be carefully balanced. So that is why we had said that there should be a classification. And there will be certain websites which are directed only towards minors. They should be classified in a higher category and greater restrictions applied to them. And that will be the job of the monitor. Like, in the Reserve Bank has what they're known as the significant, what is that? SIFI. In the financial parlance, you call them SIFI. And there is greater protection and greater monitoring of that than an ordinary institution of financial institution. Similarly, here we have said, we call them significant data fiduciaries. For them, there should be stricter law applicable with regard to breach, with regard to monitoring, with regard to periodic reports. All that has been conceptualized and provided for in the law. Of course, if the law as and when it comes out.
So you think that the existing laws that we have along with the Data Protection Act will be sufficient enough to protect the minors from...
I'm telling you, this is a big issue. I'm divulging some interesting confidential info. Because this was a big issue with 11 members sitting and deciding it. And The question is, why should we deprive the children of this facility that is available to them on the internet? They are smart enough to access the internet. Why can't they have it? And then the question is somebody trying to steal away their data and cause liability to them, we must protect. Because this is in the same way. Supposing, let's say, you're a businessman, you come to my grandson and take something in writing from him, a promissory note from him. What has happened is you got fooled. He's not going to get fooled. Tomorrow when the matter goes to court and established and says this was a minor, then you're the one who is going to fall into the trap. So therefore, this is a question of what you call caveat emptor. If you are selling something to a child, you better be careful. Make sure that he pass the age of consent. No, but you have not considered this aspect. Consent is all right. Minus consent is one of the issues. But do you know, in this country, people just even don't know what to consent to. Now it's all right. We are all sitting in Mumbai talking in English, talking in Hindi or whatever language that we understand each, or Gujarati for that matter. Now you walk down 200 miles into the interior. That man may not be able to, first of all, read a piece of paper, understand what it is, and you tell him, well, will you consent to data being taken? What the hell will he tell you?
Correct.
Isn't it? Number one. Number two, our country is a country with some 26 official languages. Each language, now if you walk into with a Hindi gazette notification to Tamil Nadu and show him that and ask him to consent, he will throw you out. He will not even look at you. This is the problem. There are 26 languages. The people who don't understand any language, people who do only thumb impression even today, how do you reach it to them? This concept of consent. So this was one of the biggest issues we had to consider. And we said the Data Protection Authority will be charged with this, that it will be his job to educate people, his job to come out with pictorial representation. For example, if you say no smoking board, nobody will read it or people will not understand it. So if you put a cigarette and a cross on that, or you have poison and that skull and crossbones, this kind of thing can, for example, traffic boards. Why do you think traffic things have pictorial representation? Because every driver may not understand what is written there. That is one of the best methods in which consent has to be handled. This is one of the biggest issues going to be there, and I hope they solve it properly.
Okay. We saw recently a controversy yesterday taking place about Pegasus, which is that Israeli software.
Since the morning, now, at least 6 newspapers have called me and asked me questions.
Sir, and I, I want to understand one thing, sir, from your, vast experience that you've had. Pegasus is a clear breach, not only of privacy, but of democracy, in my opinion.
Yes.
Now, if X party is at fault or Y party is at fault, I don't want to get into that. But to me, do you think that the Data Protection Act, if it were in place today, say assuming that it was up and running, say it had been passed into a law since 3-4 months or something, or say even in a year, do you think that if nobody were to bring a case about the Pegasus as a larger threat being presenting to not only the privacy law, but the democracy itself, do you think that the Supreme Court itself could invoke that act to address this issue?
Article 32 protects my fundamental right, right? There's no doubt about that. Let's say if somebody applied Pegasus and stole away my data. Today there is no law. Therefore, even with Pegasus, I can say it is Article 21. But with the data protection law in force, I can do two things. I can enforce my fundamental rights under 226 or 32. I can also sue the person who is responsible for it and seek damages. If it's a private company, we have said if it's an international company, it should be some 5% or 10% of their global turnover, which is going to skin them alive. And if it is a government, then they have said the man in charge of the department must be skinned alive. Now that is why the law is necessary. Today there is nothing. Okay. We just talk of privacy. What privacy? What law is there? What remedy do I have? Except that Supreme Court put a Swami judgment saying Article 21. I can't go to the Supreme Court. I am poor man sitting in Bombay. How do I go to Delhi? Particularly with the COVID.
Yes. Okay. I got the point, sir. I have one question from the PPT that you presented. There were some exemptions in which you have mentioned as one of the things is research and archiving purposes.
Yes.
Now, don't you think that that's a little overbroad or ambiguous, should I say, that I can get access to so many things under the garb of research or archiving purposes? Say I'm a librarian or who's basically a spy, or an archaeologist who's basically a spy of another country.
All right.
And I'll say that, I want to get access to a lot of archives because I'm an archaeologist or I'm somebody who's an anthropologist or something of that sort, and then get access to information. Don't you think that that's
that is not the concern really. Even today, you have access to the archives. You can go to the National Archives and do research on Mahatma Gandhi's slippers and his glasses and all that. That is not the big issue. The issue is whatever is currently available. How do you, now suppose, for example, you see, sometimes genealogy. Somebody will say, I belong to the Aurangzeb family. Does he belong to the Aurangzeb family? I mean, for belonging to Aurangzeb family is bad. Let us say I belong to the Shivaji Maharaj family. Now, in order to establish that, how to dig up a lot of data, and that data has to be collected. People walk around, no? You have seen, people say that I am so and so, I am the descendant, Shishya of Shankaracharya Maharaj. Are you there? Is it so? How do you establish? This is one aspect of data. The other aspect of data is, I think recently, the Chennai High Court addressed it, the Madras High Court addressed it, that what happens is, this is what is known as deletion of data. Now, let's say X is convicted of rape in the trial court. The High Court acquits him totally. Remember that conviction remains on record. So it will be a part of the law library. It will be there in all the books, reports. Or let's take conviction by Sessions Court, upheld by High Court by long judgment, reversed in the Supreme Court and acquitted. What happens? Therefore, I am entitled to say that please delete this damn thing. I don't want this hampering my career. That is what is called data deletion. Or take another simple case. Let's say I go and you are running a bank. I come to you and open an account. 6 months down the line, I find that sorry, I'm saying this, that you don't give me good service. As I'm closing my account. And then my data is all with you. So I have a right as a data principal to say, there is no relationship between me, you and me. You are not giving me any service. I don't want anything from you. Delete all my data. That is the right of the principal, data principal, the right of deletion. Then the number 2, I want to transfer my account to somebody else. Data portability, like your mobile number portability. That should also be there. Then supposing you make these government and departments, I'm sure if you look at your ration card, your name will be wrongly spelled, your age will be wrongly given, your sex will also be wrongly given. Therefore, you have a right to have your data updated wherever. Yeah. And also, the data processor is answerable to you to say this question. Are you maintaining any of my data? You let me know. And if I find that it is wrong, I call upon you to have it rectified. These are all the dates available, rights available. Now, where is it available today? That is why all the ration cards are wrong, have wrong numbers. My ration card was showing me I was 15 years old. Till I told them, I say, even if you reverse it, I am much older than that.
One last question, sir. Given the backdrop, we've debated, a lot of things and, very, very satisfactory answers at your end, given, that you've been personally involved in this topic.
Let me finish your Pegasus thing. I forgot about the Pegasus. You see, Pegasus is a spyware that was invented by that NOS or somebody in Israel, that company, which is sold only to governments and public authorities. Please note that sell it to private authorities. Now, 2 years ago, WhatsApp had an issue that somebody's data on their WhatsApp messaging system had been infected by Pegasus. So the Pegasus then filed a petition to say that somebody has done it, that it should get removed. Now the question that arose is, how did it get infected? Who has got Pegasus into this country? And today the same question is being raised in Parliament. If the government has imported it, they should honestly get down to the floor and say, we have done it. Sorry, it got leaked out into wrong hands. Therefore, we'll control it. Or they must honestly tell us it is not imported by us all. Then we'll investigate. See what happened in France. French government has instituted a high-level inquiry. That is why there is demand that there is a Supreme Court judge should inquire into this.
Yes.
Because this is a very important thing.
Yes.
Would you like all your messages going back and forth on your phone to be always constantly monitored by somebody sitting somewhere else in the country?
True.
That is the Pegasus problem.
Right. I get your point, sir. Now, my last question to you before I allow questions is data privacy, data protection. The next, say, 50, 60 years are going to be based on data. That is the new mantra, the new nectar, if you may call it, on which the whole world is going to move.
Yes.
Digital privacy, etc. 70 years we've given ourselves this constitution, since 70 years now, 71 to be precise, 26 January 1950. We've seen over 105 to 110 amendments to our constitution. Do you think that it would be right, say, for the Supreme Court to suggest to the Parliament, because only the Parliament can do this, under Article 368, to amend the constitution to include right to privacy or data protection combined together and formulate an article?
So why do you need that? Supreme Court?
Right. Now that judgment, the Supreme Court judgment is there, sir, but once a Parliament on its own accord, sir, understand what I'm trying to say, once on its own accord, if it gives, it puts in an amendment, what is wrong with it?
You are barking up the wrong tree. Now, right to life is already there in the Constitution under Article.
Yes.
All the Supreme Court has said is right to life. This is a part and parcel of right to life. Today, the same protection which is available to me under Article 21 in respect of my freedom, in respect of Article 21 rights is available to this. But putting it somewhere else, you may downgrade it. Now, for example, clean air. Where do you get this? Right to education. Where do you get this? Supreme Court is what Supreme Court? Of course, Supreme Court is as you rightly say, all brilliant minds sitting in Supreme Court. They made it come out of Article 21. The moment you come out of Article 21, please note, all this nonsense will not be available there. You have to have completely different types of restrictions there.
Sir, I understand all this. I understand the law. My question is that when a Parliament goes to enact, today if a Parliament enacts the Uniform Civil Code, applying Article 44 as a directive principle. Now, Ambedkar was obviously a visionary. He saw that that this country would be around 1 billion people at some time in the future, and there'll be too many problems in this country on religious basis. So he obviously wanted Article 44. He did not just put in there just for the heck of it. He obviously saw much farther in the future. What I am looking at is that when I, on my own, as a Parliament, because we are a parliamentary democracy, and we are not going to change on that. If I put in an amendment myself, then there is very little that I can do to throttle it. And my data fiduciary or my data protection authority is going to be more sentient about it rather than worry. He'll say, "Arey, theek hai na, baad mein jo bhi jhagda ho gaya, to court mein jayega, dekha jayega." But when there is a Parliament has put in an article, he has to abide by that only in the first place. Then it will be the Code 21, 32, right to privacy, right to life, right to personal liberty, full panoply of 14, 19, 21. All the three tests, the proportionality principle, adequacy principle, constitutional morality, and whatnot. All that comes later when it goes to the court of law. My question is more academic, sir.
You are right. The Constitution can certainly do it. I'm not saying it cannot. But the Supreme Court cannot tell the Parliament and say you amend the Constitution.
No, suggest karo.
Supreme Court
suggest karo. Sir, what was the advisory jurisdiction of the Supreme Court for? Presidential questions to the Supreme Court. What were all they? What are they? Sir, wahi to hai na.
Then the president should ask the question, no, shall we make an amendment to the Constitution?
Agreed. I agree, but that is once president sir, we all know what are the limitations of a president. Right. We know how powerful the Supreme Court is, sir.
All these fundamental rights, because there is no enactment, Supreme Court had to, like a magician pulling out a rabbit from the hat, come out with article. Right to life include all this, therefore we are saying this. That is all. I have no problem with that. If the Parliament does it, fine. Because all these are again like any other fundamental rights in Part 3. There is no difficulty on that.
True.
But the question is, amending a fundamental right, amending the Constitution is such a painful process.
But sir, it is.
562 people.
Sir, we can abrogate 370. Sir, we can abrogate 370. Yes. We can talk about 35A, whittling it down. We can whittle down several things. 44th Amendment, right to property was taken away as a fundamental right. It's still not seen the light of the day. Sir, then when those things have happened during the earlier regimes, then why can't this be done? That is my question.
The point is, it should have political will to do it, no?
That's the point.
If you are interested genuinely in the citizens of this democratic country, citizens' rights, I agree. If it was a prime minister like you would say, why not we amend the constitution and make sure all this nonsensical Supreme Court judgment is not necessary? Straight away give it as make it a fundamental right. We'll recognize it.
True.
I agree. It can be done, but it requires that much of political maturity to do it. And 564 voices in Parliament are not going to be unanimous. 75% at least should be unanimous, and then 2% of the states have to be.
True. So that is the main issue. Yes, that I understand. But at least some debate in that direction can start. That's the only point that I'm trying to make. I mean, it's going to take a long time before we see a lot of changes.
Please note, right to education. After the Supreme Court said it, they added an amendment, some 51.
Right. Exactly. So that's what I'm saying. Now the Supreme Court has laid down the whole roadmap for the next 100 years. Now there has to be some political will and maturity. That is what I'm trying to say. That also the Supreme Court will have to instill. The Supreme Court is the ultimate grandfather, sir. The Supreme Court is the ultimate grandfather who's going to put everything in check. Without this Supreme Court, this democracy is a teasing illusion. And Ambedkar was absolutely right when he gave that power under 142 to the Supreme Court to have that, to do any order and justice. When he did that, he knew what he was doing.
On that, I have no second opinion at all. I totally agree with you.
Okay. Thank you very much, sir. It was a pleasure. Now I open this to questions. I believe Mr. Juzar Korakiwala has a question.
Yes.
Sia, if you can, Shelby, if you can unmute Mr. Korakiwala.
Mr. Korakiwala, kindly present your question, sir.
Yeah, thank you. Your Lordship, this has been a great learning for me, not being a lawyer. Just as a common citizen, as a great learning where we know that data is the new oil. My question, sir, is very basic. I have a freedom of right to move anywhere I want without being detected. Now we have CCTV cameras all over the place, in public places, in private places. So what is the data privacy situation as far as CCTV cameras are concerned all over the country or in the cities or in malls or what have you? What is the stand on this?
CCTV is a necessary requisite for security purposes. There's no doubt about that. Now, one of the fundamental principles is when you enter a shopping mall, there will be a CCTV on that. By implication, you are consented to your picture being taken by that CCTV. Otherwise, you can say, I don't want to come to your mall. Very good. Now, you also notice on some of the roads, they have this cameras, speed cameras. Right? Now, that also causes a violation technically. In the sense they take your picture, your car's picture. Now, that is intended for a larger public good of ensuring that speed control is maintained on the highway, that the speed limits are maintained. Now, if you say, I don't want to do it, then you can go through the gully where there is no speed limit. There is no camera. See, the point is, this is not a situation where somebody is giving you service and saying, I will not give you service unless you agree to all this nonsense. No. This is in the larger public interest. Because if CCTV is not there, you will not detect the people who are crooks who come into this, pick your pocket or steal something and run away from there.
But sir, in London, the CCTV cameras on the streets. So which means that you need a consent to walk on the streets, or how is it? It's on the streets, in public places.
No, they have an act which the police act gives them the power. Because the crime is to be controlled, there will be an act which will empower it. You see, Parliament says that there should be a CCTV camera in every street in our country. That will be the law. That will be that will be the exception to the data protection authority.
So one more question, quick question. What is your view on Cambridge Analytica? Is it a breach on data privacy where they did profiling of people?
There's no doubt about it. If the law were in place, somebody could have sued them. Now you can't do anything because there is no law as such.
Thank you, sir.
Okay, there is one more question. Somebody by the name of Srinivas Annamraju has raised his hand. Can you please unmute Mr. Srinivas so that he can ask a question?
Sir, please ask your question. I've unmuted you.
Hi, good evening, sir. Actually, my video is also muted. I mean, it's cut off right now. Can you hear me, sir?
Yes, we can hear you clearly.
Yeah, can you start the video?
Yeah.
I've just, yeah.
Hi. Good evening, sir. So actually, I have a question related to Cambridge Analytica itself. I mean, a few years ago, when the scandal broke out that they were harvesting data from Facebook to create psychological profiles of users,
Yeah.
I mean, is there anything that we can do to, keep ourselves from being profiled? Because so the crazy thing is that even if we don't have a Facebook or a Twitter profile, they can still profile us using things like browser fingerprinting and metadata. So is there anything we can do to stop that from happening?
It's difficult to stop it. Of course, there could be a technological solution that I don't know, somebody may come up with an app which will say that nothing of this will go out unless I consent to it. That is possible technologically. I'm just theoretically thinking. But assuming that is not today available, then all that can be done is if somebody has done it, you can certainly complain to the Data Protection Authority and have it stopped then and there. Now today, even without all this, I can do profiling. I can sit outside your room and then say, this man has a long hair, he goes to this such and such a hotel in the morning for his breakfast, such and such thing. He attends such and such meetings where he talks about such and such subjects. This is being done regularly by the police. In fact, police department called Special Branch, which is exactly, of course, they may not profile you unless you are in their causing trouble to them. But if somebody makes a political authority, political person, or a trade unionist, or somebody who comes into the public and talks, you know something? Every one of my public speeches are being recorded. Somebody will be there in Mufti and taking down. Of course, now they don't have to take down, they have to use a mobile.
Right.
That is entered into some register.
So I hope that answers your question.
Yes, so actually the problem which I have is that the right to consent is actually being taken away from us.
Therefore,
Because even if...
Therefore, the law as the proposal in the bill is, you shall not take away my right unless there is a parliamentary warrant for that. Parliament must pass a law and say, under these circumstances, you can take Srinivas's data without his consent. And that law has to constitutionally pass the muster of the triple test that Supreme Court laid down in Puttaswamy case.
Right.
Otherwise, it is unconstitutional. That is why, if you remember, when Arogya Ketu was first brought in, I was the first person to complain. And I said, it is wholly unconstitutional. And then quietly the government backed down and said, all right, we'll not make it compulsory, we'll make it optional.
Right. And actually, this is why, to bypass all of this, I mean, they're taking identifiers such as your device info and all of that, and they're using it to connect various aspects of your browsing habits, your using habits, where do you go and all of that. They make a profile even without identifying you in real life.
Yeah, forget the state. It's being done by regular private
Exactly.
Now, every day I get 20 emails asking me whether I would like this kind of a jacket, this kind of a tie, this kind of... I never gone to them. I don't know from where they got my email ID, from where they got the interest that I wear a jacket in the first place.
Exactly.
Where did they get information? This is all profiling only.
Okay. I think there are two more questions.
Thank
Mihir Govikar wants to ask a question. Mihir, go ahead, please.
Good evening, sir. I just like, first of all, I just like to say that I think there's a lot of paranoia about data being used and profiling, because whenever we are using any services, I believe there is always going to be a quid pro quo. If you are using somebody's services, they are going to use your data and ensure better availability and development of the services. So I think there has to be an understanding among the citizens as well that if you want better services, they'll need more data to develop their services in a better manner. But now my question actually is that according to the GDPR, the service providers have to comply with its provisions, even if the service providers is in India. Now, how will the service providers be able to reconcile the differences between the provisions of the data protection laws of different jurisdictions? And can there be a possible worldwide convention for data protection like there is for arbitration or for mediation?
Exactly, you're right. I was invited to speak at the Singapore FinTech 2 years ago. And this is the one thing that I said. Hey, look, every country says, my laws are supreme, my laws are sovereign, nobody can interfere with it. I don't care what happens to you. If every country in the world were to do it, can the world carry on its affairs? That is why you invented United Nations, no? What do the United Nations do? It looks at what should be the average law that is applicable, arbitration, Companies Act, IPR, you name it, health, education. They have standards laid down and saying this is the standard that should be applied. And every member of the United Nations is expected to bring in domestic legislation in that for that purpose. So I have a feeling that seeing down the line, there will be a uniform platform which will say this should be the standard data protection law all over the world. In fact, in Singapore, they have an institute called the Asian Business Institute or something where they invited me, where they're working on this kind of a model, saying that this should be the common platform, common thing that is there. For example, company law. Company law is different. In fact, in America, that is more confusing because each company law of each state is different. In a company, for example, right now, California has introduced data privacy under the Consumer Act. Now you just walk across and go to Nevada, there is no such law. This is interesting. Imagine in Maharashtra, data privacy is there, but you go across and go to Andhra, it is not there. Go to Karnataka, it is not there. Go to Goa, it is not there. It will become like prohibition then. Cross across and have your fill and come back. Therefore, there should be kind of a central legislation. And that is why this is an act which has to be passed by Parliament. At least in a country like India, it must go across the country. And the Data Protection Authority will establish some kind of common standards. Now, internationally also it is possible that after all this, for example, take in banking. Swapnil will tell you, that is what is known as the Basel. Basel is the one that gives you norms of what should be the capital adequacy norms, what should be this kind of norm, how to treat NPA. They establish, and every member of that automatically tunes his own law in such a manner that it applies. Surely it will happen in IPR, it has happened. It can happen in data privacy also.
Okay. I hope, Mihir, that answers your question. I have got another question from Rajalakshmi Rao. Rajalakshmi, go ahead, please.
Sir, I want to ask you, the reason why they're delaying the government in bringing this act is because in the name of terrorists and various activities, under that pretext, they are not doing anything ever since you have actually sent this, your report. So what do you feel we should do, since terrorist activities are also really a nuisance value for all the citizens? How do we differentiate this?
The 2018 Act, we had said 3 sections, I think 35, 36, 37 or something like that, that you want to control these kind of activities, bring in a legislation with a specified object, which is exactly what the Supreme Court said. The law can say, this will control data of this kind of thing. This is the mechanism by which it will be done. And this is the proportionality test which has to be applied. Now, what is happening? Do you know what is happening today? Under the Information Technology Act and the rules, I was told that about 300 to 400 applications are made for phone tapping. So people have no time because it's all to be done by some secretary or somebody there. He has no time to be, he is busy chasing the ministers and the ministers calling him up and down. So they keep it all together. Over the weekend, about 3,000-4,000, like that, he will sign it and send it off. That is why everybody is at a risk. But if there is a law which says you can't do it, then jolly with. Now, for example, a law says that you can't be arrested easily. You can't be arrested unless there is a warrant issued by an appropriate judicial officer. You can have a law like that. That is exactly what we had said. But then there was so much hue and cry, and ultimately we toned it down and said, all right, let the parliament consider it and have an appropriate authority. You see, the problem is, this is going to run across the board. This is going to affect government's departments also. If you think the authority is going to be an executive officer, do you think who is ever going to say no to an application made by another government officer? Certainly not. That's why we said an independent authority must be established.
Okay. Right. Thank you, sir.
I believe if anybody has got any questions, then please raise your hand. Otherwise, we'll close this session with a word of thanks from who's there? Anybody else to ask any questions? I think with that we can end the session. Sia?
I think, I think there are no more questions. Thank you, sir. So as we come to the close of this highly knowledgeable session, may I request Mr. Juzer Khorakiwala, President-elect, IMC Chamber of Commerce and Industry, to present the vote of thanks. Over to you, Mr. Khorakiwala.
Thank you. I think we have had a very, very enlightening and incisive dialogue between Swapnil and his lordships, B.N. Krishna. Thank you so much for spending your valuable time with IMC. It's been a great learning for all the participants about data, which is actually hot news today on TV with Pegasus and what all that is going on. So as we rightly say, data is the new oil, and it will find its own level as water seeks its own level. So it's a very, very challenging subject by itself, this data privacy. So thank you so much for enlightening us, your lordship, and to Swapnil as well for organizing this event in such a brilliant manner, and for such brilliant narrative that you have, been questioning his lordship, and he's been up to it to respond to you. Thank you so much, Swapnil, on behalf of IMC and all those who have helped to put this event together. Thank you all.
Thank
And
you.
good evening.
Thank you. Thank you, sir. Thank you very much. Thank you, Mr. Kurakiwala. Thank you, everybody, for participating. Thank you. Thank you very much. Thank you very much once again, sir. Shri Krishna, sir. Thank you.